And with power of attorney, it expires if something happens to you. The same goes for medical directive. There are a couple of things that an agent can still do. And a lot of people don't know this. A lot of healthcare providers don't know this. A lot of funeral homes don't know this. An agent can still consent to cremation for a person. They can consent to organ or body donation for a person. I had a lady who had 2 little kids and had a best friend. The lady just passed out of cancer, and we're trying to get cremated, and it's just getting all this pushback from the funeral home saying we need the next of kin to cremate her. And I read the statute, and it says, or an agent under a medical directive. And so I got it all sorted out, and we've got it, they did it, it was fine. But they gave the family a hard time about it, with a friend a hard time, and there was just no need, because a lot of people just don't know what the law is. But the agent does have the authority under the statute to do that. Okay. Unlike power of attorney, divorce does not terminate an agent's authority under medical directive, which is just silly. But if I had an ex-husband, he could still, if I had his name, he could still come and say, oh, I want to see Joley's records or whatever. So you should always redo it if you get a divorce. And you can include language in your medical directive that says this terminates if I get divorced. Again, pick someone you trust, who's willing to do, who's willing to help you, and who's going to be loyal to your wishes, and who knows what you would want them to do as far as medical care. And that's again reiterated here. Okay, and we're finishing up. This is what's called a limited psychiatric medical directive. And this is for, I do this for my clients, particularly if a person has early onset dementia or has a lot of people have a traumatic brain injury, it's too late to do it. But what it says is, if I am incompetent or if I'm not making decisions in my best interest due to my disease, if I have Alzheimer's and I'm refusing medication that's in my best interest, then this allows another person to consent to that on my behalf. It's called limited psychiatric medical directive over protest, because if I'm not with it and I'm protesting some treatment that I need, another person can step in and the doctors can listen to them. So this is another type of medical directive which I do for my clients. So to wrap up, why go spring clean your estate plan? To avoid probate, to have some privacy, if you do a trust or that sort of thing, or even beneficiary designations, that's not public record. You can leave your assets how you wish without being on file in the court. It's easier on the family. It reduces the cost to the estate, which means more for your family. And a probate, you want to avoid if at all possible, because it's a hassle, it's expensive, it takes time, it delays your beneficiaries getting their inheritance. And power of attorney and medical directive, this helps people avoid guardianship and conservatorship, which involves a court, which involves lawyers, and it's hard on the family. And the person if the person becomes incompetent, the court takes away all their rights. It's very hard for me to go for a judge and ask the judge to strip an adult person of their rights to make their own decisions, when all of that could have been avoided if people had just done a power of attorney and medical directive. There's just no need to have to go that route. What I provided for y'all today is it's called a record book, but y'all may have flipped through it. It sets forth, it's for your spouse, for your family, where you list all the assets you have, where they are, especially life insurance. Life insurance doesn't do anybody any good if the family doesn't know where the policy is and have information about it. It lists, if you have people that help you with your finances or an attorney, you can list them in there. It goes into detail. You can spell out your final wishes if you want, certain things done, service or that sort of thing. You can put that in there. And of importance, it says where your legal documents are. Where's our power of attorney located? Do I have a safe deposit box? So this you do more so for your family than for you, but it's just, I had it a couple the other day, and the husband runs the show with regards to finances. If something happens to him, Miss Wilma is going to be lost, right? So we're going to go fill this out, because that way she'll know where everything is and what she needs to do. Yes.
I have one question on the directive. What about the DNR?
DNR is different than that. Yeah.
If I say I don't want anything to keep me alive, right, that's not the same as don't necessitate.
That's not the same.
I have to have a special paper.
Yes. A DNR, people normally do when they go, when they're admitted.
Yeah.
You sign a DNR every time you go.
Oh,
And there's something now in Virginia called a DDNR, which is a durable DNR, which says, I'm going to sign this once, I'm going to give it to my provider, and I don't have to do it again. But that's different, because that's a different type of treatment. That's, resuscitation and all of that. The medical directive has doesn't deal with those type of health issues. Yes, sir.
May I find this on the internet?
There was a website, yes, sir, and I don't know if it's listed in here. But I think if you Google the name, you can find the website that was on. It may be in here, but I have extra copies also if y'all need some. Are there any other questions? I'm sorry for keeping y'all longer than I'm supposed to.
No, we're fine, we're fine.
Yes, ma'am.
Back to if you die intestate, if you are married, never having been married before and you have children.
Right.
I was a little confused on that first one.
Then everything goes to your children, equal shares.
No, if you are married,
Right.
you die and your spouse survives you,
Right.
and you have children.
Are they of that marriage?
Yes,
Then everything goes to the spouse.
but if you have children from the previous marriage,
Your spouse gets a third of the probate assets,
and
and the children get 2/3.
Okay, is that a change? I thought it had always been. Yeah, I thought it had always been a third and 2/3.
That's what it is now. 2/3 goes to the children, and 1/3 goes to the spouse.
Right.
Right. So how is that different than when it?
Well, what you're saying is if there was two marriages. I'm saying if there was just one marriage.
If there's one marriage, if I'm married for 50 years and all my kids are of that marriage, and something happens to me, my husband gets everything. It's when you have kids from a prior marriage, the law protects their interest in your estate. But if they're all of that marriage, then the spouse gets everything. Are there any other questions? No? Well, thank you very much for listening to me today.
Thank you.